Many foreigners believe their overseas assets sit safely outside the reach of Vietnamese law. Foreign bank accounts, foreign real estate, offshore companies. Until marriage enters the picture, these assumptions often go unchallenged. Once a marriage is registered in Vietnam, a legal framework applies automatically. Vietnamese marital law begins classifying assets, income and liabilities. The question is no longer where the asset is located, but how it is legally characterized. Foreigners often assume that assets held abroad are automatically separate property. Under Vietnamese law, this is not guaranteed. Without a marital agreement, foreign assets can still become part of a joint property analysis. Vietnamese courts focus on when an asset was acquired. Assets acquired before marriage are generally treated differently from those acquired during marriage. Without documentation, timing becomes difficult to prove. If no agreement exists, Vietnam applies a statutory marital property regime. Income generated during marriage is often presumed joint. This presumption can extend to returns from foreign investments. A prenuptial agreement is the most effective tool for protecting foreign assets. It allows spouses to define what remains separate from awareness of future growth. Without it, control is replaced by presumption. A strong prenup must clearly identify foreign assets. It must define how income appreciation and reinvestment are treated. Vague references create enforcement risk. Phrases like personal property or overseas assets are legally weak. Vietnamese courts require specificity. Precision determines protection. For foreign entrepreneurs, equity interests often grow during marriage. Without careful structuring, growth may be classified as joint property. A prenup must anticipate this trajectory. Even if ownership remains separate, disputes may arise over control or value. Vietnamese courts examine substance, not labels. Clear allocation reduces litigation risk. Some foreigners attempt to protect assets after marriage through postnups. While possible, postnups cannot fully undo earlier classification. They are corrective, not preventive tools. A prenup alone is not enough. Proof of ownership, source of funds and asset history matters. Courts rely on evidence, not assumption. Using nominee arrangements or informal trusts creates vulnerability. Vietnamese courts prioritize transparency. Opacity invites reclassification. Some foreigners rely on foreign wills or foreign marital contracts. Vietnamese courts apply Vietnamese law to marriages registered locally. Foreign documents must align, not conflict. Protecting assets legally and enforcing judgments abroad are different issues. A valid Vietnamese prenup establishes classification first. Enforcement follows later if needed. If one spouse does not fully understand the agreement, enforceability weakens. Bilingual drafting supports informed consent. Courts take this seriously. Asset protection becomes harder once disputes begin. Positions harden, evidence disappears and options narrow. Early structure preserves flexibility. No legal instrument offers absolute immunity. But a properly structured prenup dramatically reduces exposure. It replaces uncertainty with defined outcomes. Foreigners marrying Vietnamese nationals should view marriage as a legal event. Asset protection requires planning, not reaction. Structure must come before sentiment. Foreign assets are not automatically protected by distance. In Vietnam, protection is created through legal design. Those who plan early protect control, those who delay inherit risk. Planning to marry in Vietnam. Do not assume your foreign assets are protected by default. At LTS Law, we help foreign investors and expats structure prenuptial agreements that safeguard overseas property and business interests under Vietnamese law. Visit lts.com.vn to book a confidential consultation. Protect first. Promise second.